Chinese American Federation was founded like 15 years before, and we have over 120 of the different association combined together. Actually, the target for this association, just for the local Chinese Americans and the businessmen and some of the associations, we try to get together to help each other with the business and some all the related with the Chinese American over here. And we did pretty good job on a lot of the issues. And for this seminar, we just found it recently, a lot of people talking about accounting, the PPP support, and a lot of the visas and immigrations or something. But recently we are thinking about it's more pretty important for us to know our right when the Chinese American over here, the businessmen or scholars or some of the students, if they got being questioned or being targeted, and what we need to be a response on that. That's why we just asked Mr. Pang to help us to host this seminar. I think this is going to be very helpful for our members.
Is it a membership organization? Do you have to pay dues to belong, or is it just how does it work?
You mean how to join with the members?
Yeah, the association. How is that set up? Is it?
Oh yeah, actually, you can join with the membership with your own association, or personally as a businessman, kind like that, and you have to fill up the application, and every term is like 2 years, and every year you have to pay some of the member fees. It's not expensive, kind of like free, but you have to pay the member fees to be the member. Okay. Yeah, this is we have all the application forms and all the introduction in our website.
Okay, and you have like monthly meetings and.
Yeah, usually we have a monthly meeting, and we always have like a lot of events to be held by our association. Especially as at this pandemic time, so nobody can get together, so even cannot be over like 10 people.
Right.
That's why a lot of something we just do that online.
Well,
in the past like a few months, we donate a lot of the medical supplies to all the over 40 different hospitals, and some nurse centers, some of the even some of the jails and law enforcement. To help them out with the pandemic, and donate like over 250,000 of the masks and other N95, KN95, all different kind of the emergency medical supplies when they short on that.
At least now you don't have to worry about providing catering.
The catering, yeah, you can't do that anymore. That's why.
Okay, now it's 2:10. I think we should start, right? What do you think, Simon?
I think so. Yeah, we can keep going forward, and in case the people want to join in, they can, anytime they can join with this Zoom meeting. And later on, we will have our PPT and recording and put on the website. And if they miss some part, and they can go on the website to find it out, or to to catch up with it.
All right.
大家下午好哈，谢谢大家在今天下午抽空来参加我们美华总的专门为大家组织的这一次这个专题讲座。那么最近一段时间呢，中美关系其实是很触及到我们生活在美国的华人的切身利益，在方方面面那么在最大的一方面呢，其中一方面呢是目前来讲呢，好像因为中美关系的一些动荡，那么也会碰到说有一些执法机关可能会找到我们华人来调查情况或者配合问话一类的事情。那么这些事情呢，首先我给大家放一个3分钟左右的这个 video大家听一下。这个是美国的 FBI 联邦调查局局长谈到的关于中国的一些看法。
The greatest long-term threat to our nation's information and intellectual property and to our economic vitality is the counterintelligence and economic espionage threat from China. It's a threat to our economic security and by extension to our national security. It's the people of the United States who are the victims of what amounts to Chinese theft on a scale so massive that it represents one of the largest transfers of wealth in human history. We've now reached the point where the FBI is opening a new China-related counterintelligence case about every 10 hours. Of the nearly 5,000 active FBI counterintelligence cases currently underway across the country, almost half are all related to China. And at this very moment, China is working to compromise American healthcare organizations, pharmaceutical companies, and academic institutions conducting essential COVID-19 research. To achieve its goals and surpass America, China recognizes it needs to make leaps in cutting-edge technologies. But the sad fact is that instead of engaging in the hard slog of innovation, China often steals American intellectual property and then uses it to compete against the very American companies it victimized, in effect, cheating twice over. They're targeting research on everything from military equipment to wind turbines to rice and corn seed. The stakes could not be higher, and the potential economic harm to American businesses and the economy as a whole almost defies calculation. Confronting this threat effectively does not mean we shouldn't do business with the Chinese. It does not mean we shouldn't host Chinese visitors. It does not mean we shouldn't welcome Chinese students or coexist with China on the world stage. But it does mean that when China violates our criminal laws and international norms, we are not going to tolerate it, much less enable it. The FBI and our partners throughout the US government will hold China accountable and protect our nation's innovation, ideas, and way of life with the help and vigilance of the American people.
那么今天呢，我们很荣幸请到这个 Keith 律师来给大家做一次这个关于执法机关来调查的话，大家应该怎么配合，或者是你的权利应该是怎么样的，受到公民会有哪些权利。那么 Keith 呢，是1989年就开始从事这个刑事辩护的工作。他是今年算起来的话，已经是第31年的律师从业经验。那么他也是加州律师协会认证的叫刑事辩护专家。这个刑事辩护专家这个称号呢，只有某一个领域的1%的律师可以获得这一方面的称号。那么他是代理了很多联邦的刑事辩护，还有警察不当行为的一些诉讼。那么另外呢，今天实际上 Keith 本身是犹太人，今天还是这个犹太的一个重要的一个节日，是他们的新年。但今天 Keith 还是在百忙之中抽空给我们主讲这个讲座我们大家谢谢他抽出宝贵的时间。另外呢，这次讲座呢，因为为了能让 Keith 去顺畅的讲好这个讲座，所以讲座的前半段是用英文为主讲，不配翻译。但是呢，所有的 PPT 是中英文对照的，也就是主要的内容都会在 PPT 里面有反馈。那么大家同时可以看到的话，在大家的窗口里面可以点开有一个叫聊天室。这个聊天室呢，大家在听这些讲座的过程中大家可以有任何的问题的话就可以以文字的形式 直接在这个聊天室里面提出来以后到时候讲座结束以后呢，我们会统一由我的一个助理叫 Maggie 的，他会把大家的问题用中文读出来，并且翻译成英文给 Keith 知道。最后问答环节的话 ，Keith 的回答我将会由我的律所的一位年轻律师金律师，就是 Jerry， 他会给大家做同声翻译。那么下面呢，我是把这个主持的这个share 给这个 Keith， 由 Keith 开始他今天的讲解。Keith, please start.
Okay, thank you, Mr. Pang. Good afternoon, everybody. Let me all first wish you Shana Tova. Today is the Jewish New Year of Rosh Hashanah, and I wish you all a happy and healthy New Year. It's my pleasure to be here today to talk to you about what to do if the law enforcement comes knocking at your door. It's important to know what your rights are because, quite honestly, they're not going to tell you what your rights are. So with that, let's get started. Wait 1 second, I gotta get the right screen up here. Oh, the slideshow stopped, okay. The FBI is the premier federal law enforcement agency. It has thousands of agents stationed around the United States and the liaisons around the world. It's headquartered in Washington, D.C. at the J. Edgar Hoover Building, and it's headed up by a director who you just saw in the video, who has a 10-year term, although he can be fired by the president, as we all know happened with a couple of years ago. But the FBI is a highly well-organized, well-trained, very resourceful law enforcement agency. To become an FBI agent, you have to have some type of professional degree. You have to be an accountant, you have to be an engineer, you have to be a lawyer. They don't just hire people right out of high school like law enforcement does at local sheriffs or police departments. FBI agents are quite intimidating when they show up and show their badge. It is designed to have that effect because intimidation is a legitimate tactic of law enforcement as long as it doesn't cross the line to violate your rights. So what I'd like to do today is to educate you all about what your rights are, so that if the FBI or some other law enforcement agency should come looking to talk to you, or worse, arrest you or search your home or business, you'll know what it is exactly your rights are and what you can do. Now, I know this presentation is being recorded. Mr. Pang, are we going to be providing a translation for the recording later on, so people who don't understand will have an opportunity to listen in Chinese?
Yes, we can do the screen script later on.
Okay, great. So if you don't understand everything I'm saying today, don't worry, you can go back and watch it again. But the slides are designed to be as informative as possible, and you can always look at the slideshow at any time without the commentary. Okay, you have several rights that apply when the FBI comes to your door. Let me explain how this works. So the Constitution of the United States is set up in several parts which describe how the government is organized, but the first 10 amendments to the Constitution are what they call the Bill of Rights, which some of you may know from taking your citizenship test or just from your general educational background. But the Bill of Rights is designed to tell the government what they cannot do to people. And in the context of the criminal law, there are 3 separate amendments that apply: the 4th Amendment, the 5th Amendment, and the 6th Amendment. And I'll go through each of them in turn. Now, these rights apply to everyone in the United States. It doesn't matter if you're a visa holder or a lawful permanent resident. It doesn't even matter if you're here illegally. If you are here in the United States and you are contacted by law enforcement, these rights apply to you equally without regard to your status. So if you are worried about your status, that's a separate issue. It doesn't mean that your rights don't exist and that you can't enforce them. So keep that in mind, that there may be immigration consequences to any given interaction with law enforcement, but as far as the way they're supposed to treat you, they have to treat everybody equally regardless of their status. Okay, this is the Fourth Amendment. It's quite a little bit lengthy, so I'll just read it quickly. You can follow along. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So that breaks up into two parts. There is the unreasonable search clause and the warrant clause, and I'm going to talk about each of them separately. So there's really two rights. There's Fourth Amendment Part 1 and Fourth Amendment Part 2, and we'll discuss each of them in turn. The Fourth Amendment prohibits the government from conducting an unreasonable search and seizure. If by law the search and seizure is deemed reasonable, then there is no Fourth Amendment violation. But if the exceptions don't apply, then you have what's called an unreasonable search and seizure, and you have remedies. In the context of a criminal case, if they seize evidence illegally, that evidence can be kept out of trial. And in the context of a civil case, you may have the right to sue law enforcement for violating your rights. The second part of the amendment talks about warrants. Now, a search warrant or arrest warrant is the preferred method by which the government is to take someone into custody or search and seize property. The idea behind the warrant is that it's not up to the officer to decide whether a search or seizure can be accomplished. It's up to a judge. So when you want a warrant to search or seize, you have to submit an oath, a sworn declaration to a judge that sets forth what they call probable cause. And I'll talk about that in a minute. And yeah, it has to particularly describe the place you're going to search, the house, the business office, any rooms within the business, and what it is you're looking for. So a judge can make the determination that there's information that a crime has been committed, there's probably this type of evidence is out there, and it's probably going to be found in this particular place. When the police have a warrant, the courts say that for the most part, the Fourth Amendment has been satisfied. There's small exceptions to that, but for the most part, if the police show up with your house or business with a warrant, your responsibility is to step aside and not get in their way. Now, what do you do if the police don't have a warrant, which is quite often? There are lots of different exceptions to the warrant requirement that would allow the police to search or seize. First and foremost is consent. You can agree to a search of your house or car or business. As long as it's voluntary, under what they call totality of the circumstances, a court will approve of a search that is done with your consent. There's any factor that bears on your free will is the type of factor that must be considered, but the judge is to consider all the factors that exist and then make a balancing determination as to whether or not the consent was voluntary. So, for example, the police do not have to tell you that you are free to refuse consent. But if they don't tell you that, that's a factor the judge can consider. And quite often, police will not tell you that you have a right to refuse because they're not obligated to. But if you insist on your right to refuse, the police cannot punish you because of that. So the typical example is if you're driving in your car and you're pulled over by a police officer for a traffic violation and he asks, hey, can I take a look in your trunk? You don't have to allow him to do that, but he's going to try and make you feel that as if you have no choice. And if you can show a court that that's how it went down, then a judge may say that the consent was not voluntary and the search is no good. Second exception to the warrant requirement is what they call exigent circumstances or an emergency. The police have reason to believe that someone in the house is being held captive in a kidnapping and that their life is in danger. Or the police are there to serve a search warrant and they hear evidence that suggests evidence is being destroyed. That's what's called exigent circumstances, and the police can enter the house without a warrant, and their responsibility at that point is to secure the premises so nobody can do anything nefarious, no evidence is destroyed, nobody is getting hurt, while they get a warrant if they don't already have one. When you're arrested, for whatever reason, misdemeanor or felony, the police do not need a warrant to search your pockets. They don't need a warrant to search your briefcase or backpack. They don't need a warrant to search your purse. If you have a cell phone or computer inside one of those bags, we'll talk about that in a minute, but for the most part, if you have, say, drugs in your pocket and the police arrest you for jaywalking, they can pat you down and take the drugs out of your pocket, incident to arrest. Cars, motorhomes, anything that's mobile is deemed to be an exception to the warrant requirement so long as probable cause exists. So you can see, if you see here that warrants require probable cause in this slide, there are also exceptions where no warrant is required but probable cause is required. So the courts have allowed vehicles to be searched if there's probable cause, meaning that under the totality of the circumstances, there is a reasonable person would believe the evidence is going to be found in that location or that a crime has been committed. Because a car is mobile and can be driven away where evidence can be hidden or destroyed, the courts allow police officers to search vehicles without a warrant. The inventory exception applies when you've been arrested. Let's say you're arrested for drunk driving. They tow your car because you're not capable of driving it away. You have nobody to pick it up, and it's a hazard because it's at the side of the road. They'll take it to an impound lot. Anyone who's had their car towed knows what an impound lot is. And there at the impound lot, they can search it to inventory the property so that they theoretically can make sure you get back everything that was in the car when it was towed away. And if they find something illegal, they can use it against you. Here in San Diego, where I'm located, we're 20 miles from the international border. Many of you are familiar with the border checkpoint on the Highway 5, just south of the nuclear power plant. There's also one on the Highway 15 in Temecula. Those are deemed international borders. No warrant is required. No probable cause is required. They can search you, detain you without any warrant or probable cause. So if you're carrying something illegal across the border and they search you, they will find it and use it against you, and there's basically very little you can do about it. Abandoned property, if you leave your trash outside to be picked up by the trash collector, the law deems it abandoned. So the police can come to your house without a warrant and go through your trash. And if they find any papers or anything else illegal, they can take them and use them against you in court. And lastly, special needs, that applies mainly to two types of circumstances. One is kids in school up through high school, minors. They deem that there are special needs that allow lockers to be searched or metal detectors to be placed at schools and students' backpacks to be searched for safety reasons, and other highly regulated enterprises like nursing homes or hospitals, things like that, where there's a component of people's lives are at stake, and they're being cared for, so they relax the warrant requirement, although much like inventory, vehicle searches and abandoned property, you do need some showing of need. You can't just say, I felt like searching. You have to be able to point to some type of reason why you're going to go through a student's locker, for example. Okay, what about computers and cell phones? That's a big topic these days, and there's a short and simple answer to this question in a case recently decided out of San Diego. The police, the US Supreme Court decided what the police must do before seizing a cell phone seized incident to arrest. That also applies to computer. And the answer they said is, quote, accordingly simple. The answer is get a warrant. So if you are contacted by law enforcement and they seize your computer or cell phone, then they cannot go into it unless you consent or agree or they get a search warrant. Now, how do they search cell phones? Well, if you have an Apple phone, it's encrypted. You can't be forced to give them the password, and they'll try what they call a brute force attack to try and break that password, but it's pretty difficult to do. So what they will do instead is get a search warrant and send it up to Apple or Google or whatever, and ask for copies of or your Google Drive. So if you back up your phone to the cloud, if they can't get into your phone, they can go to Google or Apple and get into your cloud storage. So that's something to keep in mind as well. And this is the court, the name of the case, and it was a rarity in these times. There was 9-0. All 9 Supreme Court justices require a warrant for the search of a cell phone, and this exception has been applied to computers as well that are seized incident to arrest. So it frequently will happen when the police will come with a warrant and to search your computers. What they will do is they will do a manual backup on their special devices and software of everything on the computer, and then that's what they will ultimately analyze for evidence, and your computer will just sit in a storage locker as evidence where you won't have access to it at all. So that's the Fourth Amendment. That talks about how the police can arrest you, how the police can search your property or your person. The most important thing to know about that, as I said earlier, you do not need to consent to a search without a warrant. You can stand pat. You can insist on a warrant, and they can't do anything to you but go out and get a warrant. They can't increase your punishment. They can't file additional charges against you. They can't do anything but get a warrant. And if they get a warrant, they're going to go in, but you are not required to consent. And they will do everything they can to make you think that you should consent. Like, this will go much faster if you consent. We don't want to have to wait here for 2 hours to get a warrant. Or, you know, what are you trying to hide? We can use that against you in court. That is simply not true. Things like that. So studies have shown that most people, law-abiding and criminals, feel a compulsion to talk to the police. It's a societal pressure that we all feel. We want to cooperate with law enforcement. but you're not required to, and they can't force you to. So that's something to keep in mind. So that's the Fourth Amendment. The Fifth Amendment talks about what happens if you are charged by the government with a crime. So this is the text of the Fifth Amendment. It says that no person shall be held to answer for a capital, which means like a death penalty case, or otherwise infamous crime, which just means basically any felony, unless on a presentment or indictment of a grand jury. A grand jury is a group of citizens, up to 23, that meet in secret and hear only from the government and receive evidence without regard to the rules of evidence or anything like that. And their sole decision is there probable cause to believe that this person committed a crime? And if there is, they'll return a piece of paper called an indictment. There's exceptions to the grand jury requirement. It doesn't apply if you're in the military or a time of war or public danger. That's really all you need to know about a grand jury. Your lawyer will handle that part of it. You can be summoned as a witness to a grand jury with a subpoena, and you have to go. And if you get summoned to a grand jury, you should contact a lawyer, because you have your Fifth Amendment right to remain silent. And you also have the right to consult with an attorney during the grand jury. How does that work? Well, if you're sitting in the witness chair in the grand jury room, your lawyer is sitting outside in the hallway. If you want to go talk to your lawyer after each and every question that is posed to you, you have the right to do that. I'd like to talk to my lawyer. They stop. You go outside. You talk to your lawyer privately. You go back inside. You either answer or you invoke your Fifth Amendment right to remain silent, which we'll get to in a minute. However, there are certain circumstances where you can't take your Fifth Amendment right, where the government has gotten what they call an immunity order from a judge. Immunity orders say that you shall talk to the grand jury and give testimony, but nothing you say can be used against you. It's as if it didn't exist when it comes to any court case. What if you don't want to comply when there's an immunity order? They will hold you in jail until you agree. It's that simple. They'll put you in a cell and you'll sit there until you're ready to give your testimony. The next clause, and by the way, we'll have a question and answer session at the end. So if there's anything I've said that you have a particular question upon, just make a note of it, and we'll get to that later. The next part of the Fifth Amendment says that nor shall any person be subject for the same offense to be put twice in jeopardy of life or limb. That's what we call the double jeopardy clause, which basically means that for the most part, the government only gets one try to prosecute and convict you. If there's a mistrial or the conviction is reversed on appeal because of some error, you can be tried again, unless the government caused the mistrial in the first place. But they're not going to let you be tried over and over and over and over. 2, maybe 3 times at most, and then the courts will put a stop to it. The next clause is what they call the self-incrimination clause. No one shall be compelled in any criminal case to be a witness against himself. That's called taking the fifth, and we'll talk about that in a moment. And next clause talks about that nobody shall be deprived of life, liberty, or property without due process of law. That basically just means that fundamental fairness applies to every criminal proceeding. The last sentence really isn't a criminal thing. This is, they can't take your house and bulldoze it to build a government office building unless they pay you for it. So these are the 4 different clauses of the Fifth Amendment. The first, the number 3 is the most important for your purposes when dealing with the FBI, because when it comes to number 1 and number 2 and number 3, your lawyer will be there to make sure those particular rights are protected. But your right to avoid self-incrimination is something that you frequently will have to invoke on your own, because it will frequently become an issue before you've even met with a lawyer. Let me go back. So one other thing about that. So there is a Fifth Amendment privilege applies almost forever, unless one, you've been given immunity like I explained, or two, you've already been convicted of the offense. So if you're convicted of a crime and then they prosecute someone else for that same crime who may have been your partner or associate or co-conspirator, they can call you as a witness in that case, because nothing you say can be used to punish you, because of number two, the double jeopardy clause already applies. Except, of course, if you lie, then you can be prosecuted for perjury. The last amendment that applies is basically how trials go. In all criminal prosecutions, you have the right to a speedy and public trial. A speedy trial, there's lots of exceptions to that. It's just generally a rule of thumb. You can't be held for years without a trial, without your consent. In state court, they set certain time limits on when things have to be done, when you have to get charged, when you have to get arraigned, when you have to go to trial. Same in federal court, but there are certain exceptions that apply, including what they call complexity of the case. And in the case involving the Economic Espionage Act, that those cases are frequently complex, so the normal rules of trial don't apply. But if you're caught, say, smuggling an alien across the border, or drugs across the border, or in possession of drugs, and it's just you, the case is not going to be that complex. Public trial means just what it says. The public and the press have a right to enter and watch. There's no secret trials here. Even in a pandemic, the courts require people to be allowed to watch, whether that the preference is to allow people in person, but the courts have approved video. So like, for example, here in San Diego courts, there's a YouTube channel where you can watch any criminal proceeding from the camera. We are operating on video now, so it's only video appearances by the defendant and the prosecutor and the defense lawyer. The judge and his staff are in the courtroom, but there's cameras and everybody can see everybody else. An impartial jury, that means an unbiased jury, selected from the locality where the crime was committed. That's called either your state, if it's a state crime, or the district. If you're in federal court, a district is basically, California has, for example, 4 districts. The Southern District of California is San Diego and Imperial County. The Central District is Orange, Los Angeles County, Riverside County, San Bernardino. The Northern District is San Francisco, Alameda, Monterey, and north of that, and the Eastern District is everything east of the Sierras. So they have to pick a jury from your neighborhood, which in some places means jurors may be coming from really far away, but that is just how juries are picked. It is basically an idea that, you know, local people know how things are done in their locality. So you have the right to be told of the nature and cause of the accusation. Basically, they have to give you the charges. There's no surprises. You don't show up at trial to find out that there's 5 charges instead of the just one you thought of. The right to be confronted with the witnesses against you. That means that the prosecution has to call. Oh, we're getting some feedback. Okay. The prosecution has to call the witnesses against you. They can't just have a police officer come in to say, this witness told me such and such. It also means that you have the right to question that witness yourself on what's called the cross-examination, which has been described as the great. So prosecution will call witness against you, ask them questions, and then your lawyer will stand up and ask questions that are helpful to you. The next portion is what they call compulsory process for obtaining witnesses, meaning you have the right to have subpoenas issued to force people to come to court to testify in your behalf. Just today, I got an email from a doctor in a case I'm working on. He says, I don't want to get involved. I said, well, I'm sorry, you've been subpoenaed. You're coming to court. You have no choice unless you want someone to come arrest you and bring you there. So if you have witnesses who are reluctant, you have the right to have them brought in. If you have witnesses who are outside the United States and don't have legal permission to come into the United States, the compulsory process clause will give you the right to compel that that witness be what they call paroled into the United States for purposes of providing testimony. And lastly, you have the right to assistance of counsel for your defense, meaning you have the right to a lawyer. But know this, the right to a lawyer under the Sixth Amendment does not apply until you've actually been charged with a crime. So when we talk about Miranda warnings in a minute, that's not what the Sixth Amendment is talking about, okay? So there's 6 parts of the Sixth Amendment, and here they are broken down one by one. Okay, how do these rights apply if the FBI wants to talk to you or search you, your house, or your workplace? I touched on that earlier. They all apply. Some of them don't apply by their own terms, like the double jeopardy clause isn't going to apply if the police or FBI wants to talk to you. They apply from the get-go, from the beginning, as soon as the police come knocking at your door and identify themselves, your rights apply right then and there. How and when can you exercise or invoke those rights? Well, that's easy. You can exercise your Fourth Amendment right by saying, I do not consent to a search of my car or home. You can invoke your Fifth Amendment right by saying, I choose to exercise my right to remain silent. Okay? There's no magic words. You just have to make it clear to the police that you are not agreeing voluntarily to allow them to do what they want to do. That does not mean that you can interfere with their ability to do what they want to do, because if they have a warrant, they're coming in. If they have an immunity order, you're going to talk or stay in jail until you're willing to talk. But they can't, you can't be punished for exercising these rights. When I was in law school 30 years ago, I had a professor who taught criminal procedure who happened to be an appellate court judge. And he was telling us one day that the police love law students. We asked, well, why do the police love law students so much? Because they think the Fourth Amendment means that they don't have to do what you tell them. And whatever the Fourth Amendment means, it does not mean that if a policeman or FBI wants you to go to jail, you're not going to go to jail. You will go to jail. You might have a remedy the next day when you see the judge, but if a police officer wants you in custody, you're going in custody. They can use reasonable force to take you into custody, whether you agree to it or not. If you fight back, they can charge you with assaulting a police officer or resisting arrest. But if they tell you, put your hands behind your back, you're coming with us, your responsibility is to put your hands behind your back and go with them quietly. Just don't say anything. What remedies do you have? Well, we talked about that too. You can sue the police for money if you think they violated your rights. I have a case going to trial next week with a man who was wanted for drugs. The police had a warrant. He tried to run away, and they sicked a police dog on him. And even though he was on his belly with his hands in front of him, surrendering, they refused to take the dog off, and the dog shredded his arm. And he had to have 5 skin grafts and spent a month in the hospital. So you can sue if the police use excessive force against you. You can sue if the police search your house without a warrant. You can sue if the police arrest you without probable cause. Alternatively, or if you are being prosecuted, then you can ask a judge to let any evidence, to exclude any evidence that the police sees as a violation of your rights. So what that means is that the prosecution will give you, your lawyer, a list of all the evidence they want to use against you. Your lawyer will file papers called a motion that asks the judge to suppress the evidence on the grounds that your particular right was violated, and your lawyer will have to explain to the judge, well, this is the law that applies, and this is why the law compels the evidence to be excluded. Now I'd like to talk a little bit about the trial court or court process. It's a bunch of different steps. Could take years to get from number 1 to number 7. First, you are arrested and charged. Either you're arrested for a crime that is underway, in which case you'll be taken to jail, taken to court, charged and arraigned, and the judge will set bail. Or the prosecution can file charges ahead of time and then come arrest you as a result of those charges that have already been filed, and then you still go through an arraignment and the bail process. The next period of time after your bail is set, whether you, by the way, in federal court, you have a right to bail, but the government also has the right to try and hold you without bail if they can show the judge that it's more likely than not you're a flight risk, or that there's what they call clear and convincing evidence that you're a danger to the community. If you're released, they can hold you without bail, but most cases get bail. Your lawyer will handle all that. The disclosure at the arraignment, you will have be advised of your right to have a lawyer. If you haven't hired a lawyer already, one will be appointed to you if you can't afford one. So an arraignment will not go forward without a lawyer. That's where the Sixth Amendment right to a lawyer attaches. If you are arrested, say, for even a DUI, and you're brought to court and you don't have a lawyer, the public defender will appear with you that day to do the arraignment process, and then you can determine later who your lawyer is going to be. So after that initial court appearance is settled, then the next part of the case involves disclosure of evidence. The government has a responsibility to turn over evidence to your lawyer under the law. There are certain issues that come up, especially in these economic espionage cases or national security cases. Lawyers frequently have to get security clearances to view the evidence against you, which is a process, and if your lawyer can't pass that security clearance investigation, then you're going to get another lawyer appointed for you who can clear security. And that brings up the notion of you have a right to a lawyer of your choice. They can't, if they appoint a lawyer to you, you can't pick the particular lawyer, but if you hire a lawyer, you get to pick the lawyer you want because it's someone you need to be comfortable with. And if the court is going to kick your lawyer off the case for some reason, they have to meet a very high standard to do that. The other part about disclosure of evidence is what they call a protective order. That's where the judge says that the evidence is to be kept to yourselves. The defendant can look at it, but can't have copies of it. Your investigator, your office staff can have access to it, but no one outside the defense team can get access to it. And once the case is over, you have to turn it back in. That disclosure of evidence phase can take months and months. I have a case involving commercial sex trafficking with an internet pornography site. We've been going for a year and we still don't have all the evidence. But assuming all the evidence is turned over, once the evidence has been turned over, then the judge will hear what they call pretrial motions. Pretrial motions are opportunities for your lawyer to explain to the judge why the evidence that's been disclosed to you should not be allowed into court because either you made a statement that you weren't required to make in violation of your Fifth Amendment, or you made a statement that you shouldn't have made because the police didn't give you your Miranda rights, or there was no probable cause to search your house, or the charges are too numerous to be tried all at once, or there's too many defendants to be tried all at once. Any legal reason you can think of that the judge would have to decide is something that your lawyer can file in a pretrial motion. Those are quite complicated to do. Mr. Pang can tell you that. But once they're filed and ruled upon, that's how the trial is going to go. And if the judge was wrong, you may have the right to appeal. We'll talk about that in a minute. Between pretrial motions and trial, there is always an opportunity to try and settle your case. Most cases settle. Very few cases actually go to trial. I think nationwide, they say the percentage of cases that actually go to trial is 5 to 10%. Everything else is negotiated. Either the charges are negotiated, or the sentence is negotiated, or both. But if you can't settle, then you have a right to a trial under the Fifth Amendment and Sixth Amendments, as we discussed earlier, where the prosecution has to prove you guilty beyond a reasonable doubt using only admissible evidence. The trial has to be fair. There can't be any cheating, and you have to have a right to fully participate in the trial. If you're found not guilty, the case is over. If you're convicted of anything, then you will proceed to a sentencing hearing where the judge will decide under the rules that apply in that particular forum what sentence you should get. And everybody gets an opportunity to weigh in and make their recommendation. The court will have a report prepared by the probation department called a pre-sentence investigation report, where the judge, someone who works for the judge will provide a report to the judge about the facts of the case and everything about you, your family, your education, your work history, your drug use history, your medical history, whether you're remorseful, whether you've lied, all the information. There's no limit on the information a judge can consider when imposing a sentence. And finally, if you've gone to trial and lost, and once you're sentenced, then you have a right to appeal to a court of appeal, where the court of appeal will hold a hearing usually about 18 months after you file the appeal. The lawyer will file legal papers with the judges. There's 3 judges trying to explain why the conviction was not fair. The judge should have suppressed this evidence, and if the Court of Appeals determines that the result would have been different without that evidence that should not have come in, or would have been different had the evidence that you wanted in had been allowed in, they'll reverse the conviction and send it back for a new trial, and you'll start over under the rules that they set. If you've never been to a trial, it's a very stressful proceeding. I can tell you, for the lawyers it's stressful. For the clients, it's even more stressful. Sometimes you feel like nothing is within your control. That's where you really have to trust your lawyer. Just know that your lawyer is working very hard when you're in trial, and most lawyers will tell you that the type of clients who are always pulling at your elbow, trying to whisper in your ear when an FBI agent is on the witness stand, you're actually interfering with your lawyer's ability to do your job. That's why you keep a notepad and a pen and you write down any questions or comments you may have about a particular witness. But just know that your lawyer should be well prepared, and if your lawyer is not well prepared at a trial, then you should have another lawyer. Okay, so now we're getting to the heart of why we're here today. What happens, why is the FBI knocking on doors, talking to people of Asian descent? It's primarily, as the video indicated, because of the Economic Espionage Act of 1996. We'll talk about that in a minute, but there are other crimes which may or may not apply as well. There is conspiracy, which is an agreement to commit a crime between 2 or more people, making false statements or lying to a federal officer. So if you exercise your Fifth Amendment right and choose not to talk to the FBI, that's fine. But if you do choose to talk to them and you lie to them, you can be prosecuted for lying. And perjury is just lying under oath. So if you're called to the grand jury and you lie, or you take the stand at your trial and you lie, they can try you for perjury. But making false statements does not require that the statement be under oath. So here's the Economic Espionage Act of 1996. It's a series of laws at these code sections 1831 to 1839, and it's primarily concerned with commercial trade secrets. There are separate laws that apply to classified or national defense information. There may be some overlap between the two. So if Raytheon is working on some type of technology for a satellite that also has commercial use, it may be what they call dual purpose technology, and it may be subject to prosecution under a separate statute or both of them. There's some terms that apply that you need to be aware of in terms of the Economic Espionage Act, because it doesn't always apply to people stealing secrets on behalf of, say, China. It applies to anybody stealing secrets, and we'll talk about one of those cases. If you're working for a company and they have trade secrets and you want to go out on your own and form a rival company, you can't steal their stuff and use it to run your business. That's a crime. But foreign instrumentality, basically anything that is run by a foreign government, owned, controlled, sponsored, commanded, without limit. If someone in the Politburo, if Vladimir Putin is behind something, then it's a foreign instrumentality. And a foreign agent means anyone working for a foreign government. It doesn't have to be someone officially working for a government. It can be someone informally working for a government as well. Trade secret is defined in the statute as basically anything you can think of, whatever type. It can be financial, it can be business, scientific, technical. It involves every aspect of the design process and production process, patterns, plans, procedures, whatever it is, whether it's tangible, meaning written down, or intangible, meaning that, let's say, you know, they have a Kentucky Fried Chicken. No one knows what Colonel Sanders' secret ingredient is. Somebody knows what it is, and it's maybe, you know, just up in his head. And if he lets it slip at a cocktail party and you use it to make a rival fried chicken, you may be guilty of a trade secret because you've stolen an intangible item. It doesn't matter, again, how it's stored. It can be on paper, it can be in a computer, it can be in a mathematical formula, it can be a photograph or in writing, as long as the owner is trying to keep it secret. Okay? So the owner can't just come up with this process, and if you come up with a process and fail to patent it, then you haven't taken reasonable measures to keep it secret. The information also has to be the type that has value, either now or in the future, and isn't generally known and can't be ascertained through proper means by another person. So that's like, you know, if you're stealing from your boss to open up your own company, that's what this is talking about. But if you come up with the idea completely on your own time, then you can go ahead and run that business. Whoever has legal rights with respect to the particular property, and misappropriation means you know or have reason to know it was acquired by improper means. So let's say you're not the guy who steals the trade secret from the computer. Somebody at the company steals it and sells it to you because he wants some money but doesn't want to be involved in the business, and you have reason to believe that this stuff was stolen and you use it, you're subject to prosecution as well, as if you had stolen it yourself. There's a lot of explanation as to what this, what elements of the crime are, but you have to disclose it without the agreement of the person. You have to obtain it by improper means. You had knowledge it was gotten illegally, or you got it from somebody, or you got it under circumstances where you know that there's a duty to maintain secrecy. And, these are the things the government has to prove. They're pretty lengthy. I'm not going to read through them all, but these are all what they call elements. The government has to prove, to the extent that they apply to each particular case, all these things to show that you have committed economic espionage. Improper means is just about anything. Theft, bribery, misrepresentation, breach or inducement of a duty to maintain secrecy, or espionage through computer hacking. But it doesn't include what they call reverse engineering, where you have a product and you take it apart to figure out how it works. It doesn't include what they call independent derivation, where you come up with it on your own, or if you obtain it lawfully by buying the rights to use it. So there's separate statutes that cover different things. The first statute, 1831, covers espionage. Economic espionage applies to trade secrets with the knowledge or intent that the theft will benefit a foreign power. You can receive up to 15 years in custody and fines of up to $10 million times the value for an organization, or $5 million for the person. That should be distinguished from theft of trade secrets, which is stealing trade secrets for commercial use without regard to any benefit to a foreign power. So if you're stealing it and sending it home to China, you're going to be prosecuted under 1831. If you're stealing it and setting up your own business to compete, you're going to be prosecuted under 1832. The penalties are less. As you can see, it's 15 years for 1831, 10 years, but no fines for theft of trade secrets. But if your company steals trade secrets, you can be fined $5 million or up to 3 times the value of the stolen property. And then valuing the stolen property is often the most difficult part of those types of cases. If you're working for the government or a whistleblower, you're not subject to prosecution. Someone who sees something illegal going on and goes to typically law enforcement or Congress and provides information about that crime, technically you're in the process of disclosing information that you have a duty to keep secret, but you're doing it for a legitimate reason, so you're not going to be prosecuted. Section 1834 says the government will take the proceeds of any crime or property derived. So if you steal a widget and you use a widget to open a business and your widget makes you $1 million, the government can take the entire $1 million even if the widget only is worth $1. And then the court will, take action and enter orders to keep these trade secrets confidential. So if you're in trial for theft of trade secrets, the judge can order that you not post the blueprints to the item on the front outside the courthouse for anybody to see. Because to the extent possible, the court doesn't want to be the vehicle by which this information gets away from the lawful owner, because that's what they're trying to prevent in the first place. Companies can sue civilly, and the Department of Justice can sue civilly as well for money, where no one would go to jail. You frequently see that in the state courts here. If you work for an insurance company and you take a list of preferred customers with you when you go out on your own, they will sue you to prevent you from doing business with that list of customers. Most importantly, there's what they call extraterritorial jurisdiction, which means if you're doing this overseas, the government can prosecute you. If you're working for an American company in China and you're stealing trade secrets or committing economic espionage over there, and you're a US citizen or permanent resident, they can prosecute you here, or they can prosecute you here if anything was done in the United States to help assist that. Like if you have a partner here who you're transmitting the information to. Just being overseas is not going to protect you. So if you notice, there's nothing here that says that foreign nationals cannot be charged. Anybody can be charged with these crimes, whether or not they are in the United States or not, and whether or not they are foreign nationals or not. Okay, so this is a policy that the Justice Department adopted to decide when should we prosecute this type of cases. And they say we can't basically prosecute every theft of trade secrets. There's too much. Our courts would be clogged with them. We will rely upon private citizens and private companies to file these civil suits. And we will step in and prosecute when we deem it is important to do so, okay? And the factors they'll consider in whether it's important to prosecute are the scope of the activity. Is this a one-time thing, or is it an organized, long-running plan? Is there a foreign government, a foreign agent involved? How bad was the theft? What are we talking about here? Are we talking about a widget, or are we talking about, say, a vaccine for COVID-19? Or what do they call it? SARS-CoV-2, I think is what it's actually called. Whether civil remedies might do the job, and whether a prosecution will deter other actors. But just because you can sue doesn't mean it's there's a factor, because anybody can always sue even if there is a prosecution. It doesn't violate double jeopardy for the owner of the trade secret to sue you after the government has already prosecuted you. So how can it be used? It can be used to protect their valuable economic and intellectual property. So dishonest competitors who steal your secrets, like the FBI director was saying. If you want to be a competitor, great. Maybe you have a better product. Maybe you have a better service. Great. But you got to do it yourself. You can't rely upon the fruit of someone else's labors to make yourself rich. So it can protect your company, and it can be used to prosecute a company that violates the law. So what does the government have to prove to make this offense? That you knew or intended that your actions would benefit a foreign power. China is sending you money with the intention that you steal secrets. Number two, you knowingly, meaning you have to intentionally steal, or these other things, a trade secret, or without authorization, obtain it. So you can either steal it, meaning you don't have a right to it, or you're copying it even though you don't have a right to, you have a right to see it, but you don't have a right to copy it, or you received stolen property. So like the guy who buys jewelry stolen from a jewelry store is called the fence here in the United States, and the fence is guilty of receiving stolen property. So anybody who buys or gets stolen property, knowing it's stolen, can also be prosecuted. So it's stealing, it's copying, if you will, without authorization, or it's obtaining the information. Trade secrets is a little bit different. Trade secrets, you have to want to convert the trade secret to your own benefit, that it's related to something that works in commerce, and that you knew it would injure the owner of that trade secret if you stole it. And finally, the same elements that you either stole it or copied it without approval, authorization, or obtained it from someone who did. Elements of the offense are set forth in jury instructions that are told to the jury at the end of the case, and the government has to prove each and every one of these things in a criminal case beyond a reasonable doubt. Conspiracy law is a little bit different. Conspiracy has a 5-year maximum. It's simply an agreement to engage in criminal activity, taking some kind of step to put the plan in motion and intending to commit the crime. So if two people are sitting around their house saying, let's go rob a bank, and they get in their car and drive to the bank, and they're in the car putting on their ski masks and getting their guns ready, and the police come across them, those people will be prosecuted for conspiracy to rob a bank because they agreed to do it, took a number of steps to make it happen, and intended to do it. And how do we know they intended to do it? Well, they're sitting outside the bank wearing ski masks. Okay? The agreement doesn't have to be explicit, meaning that you don't have to have a written contract, you don't have to have a handshake. Hey, let's commit the crime of drug dealing. You don't have to have anything formal like that. You just have to know that something's going on. And a conspiracy can exist even if, let's say, 4 people decide to rob a bank, and 3 of them go in one car and the 4th goes in another car, and the 4th guy, his car breaks down and he never makes it to the bank. He can still be part of that conspiracy even though he didn't make it to the bank. Okay? That sounds pretty unfair, and it is, but that is the law. I actually represented a gentleman who was asked by his cousin to drive up to Lompoc to drive back some marijuana that was supposed to be brought in on a boat. The boat never showed up, so he left, went back home. The next day, the cousin went back up and got the marijuana because the boat showed up, and my client got convicted of conspiracy because he had agreed to smuggle the marijuana and had actually taken the step of going to Lompoc to do it. Not very fair, but legal, unfortunately. Making false statements, that's lying. So 5-year maximum, you make a false statement. It has something to do with what the agency involved works on. You did it on purpose, and it had the ability to influence the course of the investigation. So for example, the Michael Flynn case is a prime example of making false statements. He was accused of lying to the FBI about his contacts with the Russian ambassador regarding US sanctions. He tried to argue that, well, the government knew I was talking to them, so they weren't actually deceived. The government doesn't actually have to be deceived. It just has to be a natural tendency to influence them. So if he was charismatic and persuasive, and the FBI said, well, if you say nothing happened, even though we believe otherwise, we'll take your word for it, that's not a defense. That's this element. It doesn't have to actually influence the agency. You don't have to know what particular agency you're talking to. You don't have to know that the subject matter is something that the law gives them the ability to investigate. You just have to want to make the false statement and know that you made a false statement, but you don't have to do it with an evil or corrupt motive. And perjury is testifying under oath falsely that was material and you acted willfully. So almost the same elements, other than you have to testify under oath for a perjury. So if you are interviewed by the government, they have the option to place you under oath if they want. They don't have to, but sometimes they can. And if you do that, then you're guilty of both making a false statement and perjury. But the elements are basically the same. Don't lie to the police. If you're tempted to lie to the police, the better course of action is to not say anything. to say, I don't want to talk to you without my lawyer being present, period. Perjury cannot be proven by he said, she said. There has to be more than just somebody else saying that that's a lie. So, you know, like in these sexual assault cases, if there's no physical evidence, it's one person's word versus another person's word. That's not enough for perjury. So if you take the stand and say, I didn't steal my neighbor's lawnmower, and all the government has is the neighbor's say so, that's not enough. Okay, before we talk about prominent cases, I want to talk about, unfortunately, I forgot, Mr. Pang, I'm sorry, to make a slide about Miranda rights, but we will do that and add it in to the presentation when it goes up on the web. But we're going to have this part of it will be recorded. So Miranda rights, when the police contact you and take you into custody, you have to be in custody. It's not just at your house or standing out on the sidewalk. You have to have your liberty somehow restrained. Either you're in handcuffs, you're in a police car, you're at the police station, someplace where you're basically not free to leave. That's custody. And then they have to ask you questions. That's the interrogation part. Frequently, people come to me and say, the police arrested me. They didn't read my Miranda rights. Can I get the case dismissed? I'm like, the answer is, the question then is, did they ask you anything about the case? No. Well, then there's no violation of your Miranda rights. Now, what are your Miranda rights? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney before questioning, and if you can't afford an attorney, one will be provided to you at no cost. Does that mean the police are going to go out and call a lawyer for you? No. You can insist on your right to call a lawyer, but if you don't call a lawyer and agree to talk to the police, Miranda does not prohibit your confession, if that's what you do, or any of your statements from being used against you in a court of law. You have to specifically tell the police, I don't want to talk to you. Not only do I not want to talk to you, I want a lawyer. And then they have to leave you alone, basically, other than what's your name, where do you live, and what they call booking questions. You know, do you have any, they're taking you to jail, are you allergic to any medicine, that kind of stuff. But anything else about the case, there's exceptions, of course, but anything else about the case, if they don't read you those rights before they ask you those questions, they can't be used against you. If they read you your rights and you start talking and then change your mind, you can shut up at any time by saying those magic words, I don't want to talk to you anymore, I would like to see a lawyer. However, if you say, maybe I should talk to a lawyer, that's not good enough. The courts will say that's equivocal. You have to be firm. I want to talk to my lawyer. Do you have a lawyer? No. Okay, what happens? Questioning stops. Eventually, you'll get the ability to make a phone call, and you can call and try and get a lawyer at that time. But they're not going to stop and just go out and get you a lawyer and bring the lawyer in, have him sit in the room, and then start questioning you again. No lawyer would allow that. So again, it's important to know that if you're contacted by the FBI or any law enforcement agency, you do not have to consent to a search of your person. You do not have to consent to a search of your personal effects. You do not have to consent to a search of your car, your house, your office, your computer, or your cell phone. That's number one. Number two, you don't have to talk to the police, but you should to the police. So, for example, if the police Mirandize you, ask you a question, did you kill this person? And you shake your head yes, but don't say anything. You've just confessed to a murder. Okay. you have to affirmatively say, I don't want to talk to you. I want to exercise my Fifth Amendment right. There's no magic language so long as it's definitive and unequivocal. In addition to invoking your right to remain silent, ask to speak to a lawyer. They can't continue to question you if you do either of those two things. And if they do, they violated the law. And then if they break you, hold you, if they badger you for 5 hours and you finally agree to talk to them, then the evidence is probably going to be kept out. So those are the two takeaways from this presentation. Don't consent to any type of search. Invoke your right to remain silent, and invoke your right to ask for a lawyer. So now Mr. Pang asked me to talk about some prominent cases under the Economic Espionage Act. There are lots of prosecutions under this statute. Many of them result in plea bargains where someone pleads guilty to something. So the cases I'm talking about here are only the ones that went to trial, where people were convicted and appealed, so there's a record of what happened. So the first time this charge was used was Dongfan Greg Chung, who got 16 years in prison for stealing trade secrets relating to the space shuttle. They found all these documents in his attic, and he died this year from coronavirus while serving his sentence. Okay, so he was trying to sell aerospace technology to China, and he did it, according to the proof, for 30 years before he got caught. So that was the first trial, conviction, and sentence for economic espionage in the United States. And as I noted, this gentleman just recently passed away from coronavirus. This is just a little bit of details about his case that you can read at your leisure. But at his sentencing, the judge imposed a long sentence specifically to send a signal to China to, quote, stop sending your spies here. That's why he got 16 years. Another gentleman whose arrest led to Mr. Chung's prosecution was this fellow Chai Mak, who tried to sell naval technology to China. He got 24 years, but he pled guilty. There was no trial in his case. But his case led to this particular case. In this case, this gentleman, Xiaodong Sheldon Meng, got 2 years for stealing military software from a defense contractor trying to sell it to the Chinese military. And basically, it was fighter pilot training software programs. And he got a 2-year sentence because he cooperated with the government. If he didn't cooperate, he probably would have gotten much more time, because this also involved the Arms Export Control Act, not just economic espionage. So this is one of those dual use things where they can prosecute you on 2 types of charges: economic espionage and arms control. Okay, sorry about that. The next the case that I found was in Pittsburgh, where these 5 people, all Chinese government officials, were stealing information from Westinghouse relating to how to build power plants, basically. Nothing, national security interest, but Westinghouse spent a lot of time and money developing this technology, and they used computer hacking to try and get the information. They were charged in Pittsburgh in 2014. That's why it says case number 14. When you see a number like this with a dash after it, that's the year that the charges were filed in a federal case. These men have never been arrested or sent here to stand trial, so the case is just basically sitting in a file somewhere. But this is the one instance of Chinese government officials as opposed to people working for the government that I was able to find. This gentleman, Hong Jintan, applied to China's 1,000 Talents program and stole $1 billion worth of secrets from an oil company relating to energy production. He got 2 years in prison in Oklahoma. I don't have, really more details on the case. As to how that sentence was calculated, but basically the fact that it wasn't national security type information probably is what resulted in that particular sentence. Here's a case in Washington, D.C. where Shan Shi, a Texas scientist, got 16 months in prison for stealing what they call syntactic foam, something that they use in submarines, and was also destined for transmission to China, that planned to basically undercut this American company and take over the market on this stuff. So they actually got the materials to China, they created the company, and then they had the nerve to try and offer their victim an opportunity to be partners with them. Basically, they couldn't do the job on their own, so they paid to have it stolen, and this particular scientist got 16 months for his role in that particular crime. This gentleman, Hao Zhang, was convicted in San Jose, stealing cell phone technology. He was supposed to be sentenced on August 31st. I don't know if that went forward or not. I can find out and update the slide. I didn't see anything in the paper. Mr. Pang, do you have any information about this particular prosecution?
Not yet, but
okay. I think it was continued because of the COVID issues. Basically, the Northern District of California shut down. They weren't even letting judges come into the courtrooms because of COVID. But this was a case that was underway when the pandemic broke out, and they had to stop the trial in the middle and then try to restart it. These two individuals were arrested in Philadelphia for trying to steal information about ovarian cancer drugs. There was a third criminal who was living in Taiwan, and this was the first time they used this act against a foreign national, Ms. Chow, but there's no allegation that it was they were working for the foreign government. One person got time served, and everybody else was dismissed, which tells me that there was cooperation underway. They agreed to give somebody a time served sentence, and everybody else got their cases dismissed. This one was a different one. This was a stock trader in Chicago who got 18 months after stealing software that allowed high-speed trading. That's a big issue here in the United States. The average trader can't compete with high-speed trading software. This software is trading stocks thousands per second, and it's manipulating the price by engaging in that rapid trading, and they take advantage of short-term fluctuations in price. And if you're trading tens of thousands or hundreds of thousands of shares, then a penny here, a penny there in value can add up. So this gentleman was ordered to pay almost $760,000 in restitution because that's the profit margin that was made by the theft of this particular software. I remember seeing a TV program, documentary, where they talked about a company that was able to install the first high-speed New York to Chicago So they were the first company in Chicago. They had a faster internet connection than any other company in Chicago. So they were able to trade faster. That's completely lawful, and that's what you're supposed to do. But they came up with this idea, they put it into action, and it made the money, and that's how things are done. This General Motors engineer got 1 year and a day. Her husband got 3 years, and they were stealing hybrid auto technology secrets from GM to send to a competitor in China. You know, regardless of what you think about President Trump, this is the kind of thing where he does have a point that, you know, our secrets shouldn't be stolen and sent to anybody overseas. If you want to compete, compete fair and square. This gentleman was convicted after a trial in Louisiana where he got 5 years for stealing something about that is used to, let me see, I can't read it here, protect construction materials from pressure and heat. So I don't know where they use this stuff, maybe in nuclear power plants or something like that, but he stole it from Dow, which is a rather large multinational corporation, and tried to sell it to China, got caught, and received a 5-year sentence. This gentleman and his daughter were convicted of trying to steal trade secrets relating to, like, the glue that they put on stamps, for lack of a better term. Doesn't sound like anything particularly noteworthy, but it's, you know, in high demand, obviously. Lots of stamps and envelopes use adhesive, and it's a big industry. The company was fined $2 million because of it. This gentleman got 3 months in prison and 200 hours of community service after his trial in San Francisco. He was a project engineer at Netgear and was stealing trade secrets from Marvell and selling them to Marvell, a chief competitor for internet equipment. No, there's no foreign government involvement. He just happened to be of Chinese descent and was prosecuted for theft of trade secrets. I think we covered this one already. This appears to be a duplicate. Okay. We showed at the beginning of this presentation a short clip from the FBI director. This is a link to that entire speech if you want to watch it. It's about, what, a half hour, Mr. Pang?
Yeah.
Yeah. Worth watching if you're concerned about what the FBI is interested in. Okay, so what do you do? When should you contact a lawyer? You know, that's a pretty simple question. As soon as possible. If the FBI ever comes to your door, your home or your business, they'll knock on the door, they'll show you their badges, they'll present you with their business cards, they'll tell you, we'd like to talk to you, can we come in? Well, Agent Smith, I think I'd like to talk to my lawyer before I agree to any of that. If you leave your card, we'll have them get in touch with you. They'll either say okay and leave, or they'll say, well, we have a warrant for your arrest, you're under arrest, and we're going to search your house, and then they'll come in. But don't make the mistake of thinking that you can persuade or convince the FBI to leave you alone. If they're there for a reason. If they're there, they've done their homework. If they're there, they know more than you could possibly imagine about you and what's under investigation. It's like going into a gunfight with a knife, okay? You're mismatched. And here's our contact information if you ever want to talk to anyone. So I'm happy to take any questions. Mr. Pang, is there anything you think I neglected to discuss?
Okay, now we start the Q&A section.
Okay, I'm going to stop sharing now.
Okay. Maggie and Jerry, please start the Q&A section.
Okay, before we actually start the Q&A section, I want to again thank you, Keith, for this wonderful presentation. And I know there's a lot of information we have in this conference. 对，所以说今天的话，我们这边的信息量其实很大。那也感谢 Keith 给我们带来这么一场很好的一些信息。那如果说我这边简单的用中文做下总结哈。如果说大家觉得今天这个信息量很大，可能不能完全把所有东西都记住，那反正最关键的就是记住那一点：当警察来要逮捕你的时候，或者说警察来对你家里进行在没有任何的搜查令的情况下，对你家进行一些想要搜查的时候，千万不要觉得你一定要让警察进来，你可以说 no， 你可以跟警察说我不同意你来搜查我。一样的，如果说在一些被警察逮捕的时候的话，刚刚 Keith 也说了一些关于 Miranda rights 的东西，那些东西呢，可能在那个我们这边 slide 里面没有，我们事后呢会进行一下补充和添加。最关键的一点就是说，在这个警察要逮捕你的话，你可以有权保持沉默。可能我们很多时候只是在一些影视作品里或者在一些连续剧里面听到说你有权保持沉默，那你说的每一句话都会成为呈堂证供。这个东西其实是在现实生活中也是非常管用的。如果警察逮捕你的话，你最好的选择就是不要说任何的东西，然后跟警察就说一句话：我要跟我的律师联系。这就是最关键最重要的地方。对，那我们现在的话可以进行我们这边的一个Q&A。那 Maggie 你这边有什么问题？
我们这边收到了一些问题，想问 Keith 律师。首先，第一个是，如果执法机关过来敲门，我们可以要求他出示证件吗？可以对他本人和证件拍照吗？亲朋好友可以在一旁录像，并且记录整个执法过程吗？
Hi Keith, we have one question coming in.
Okay.
Basically, the question is, if the law enforcement knock on the door, can we ask him or her to show his or her badge? Can we take a picture of it? Or can anyone present, maybe a family or a friend, record the whole thing? Or take one step further, in case if there's a dispute on whether this person give consent or not with regard to the search, you know, how can we obtain evidence in that regard? Okay. If we cannot record a thing, and you know, without evidence, is there any chance, you know, this person can win, you know, arguing there's no consent being given?
Well, that's a good question. So first of all, when it comes to recording or filming the police, you have a First Amendment right to film the police as long as you are filming them from a location where you have a right to be. So you can't force your way into a police station to film what's going on in an interrogation room, but if you're out on the street and you're not right in the middle of police activity, you're like, let's talk about the George Floyd situation for a second. Mm-hmm. Okay, that's the perfect example. Those people were on a public sidewalk and had every right to be where they were and had every right to film that officer murdering that man. Okay, mm-hmm. If that had happened inside a police station, you wouldn't have the right to film. If it had happened inside a Burger King, you would have the right to film. So you certainly have the right to film in your own house. You absolutely have the right to ask a police officer or FBI agent to show their identification, and they will do so without even being asked. Taking a picture of it is probably not something they're going to agree to, but if you have a family member standing in the background who's filming the interaction and they can zoom in quick enough to get a picture of it, that's probably allowed. But ultimately, when your lawyer gets the police reports, those agents' names will be on them, and there won't be any dispute as to who they were. Why don't you translate that part, and then I'll get to the consent part in a second.
OK， 对，那个 Keith 律师是这样说的哈，就是说如果说当有警察来敲门的时候，通常的情况下他们会主动出示他们的证件。那如果说关于对这些证件进行拍照的话呢，很多时候警察也好 ，FBI 也好，他们是不会同意的。但是如果说你有亲友或者说是其他的朋友在场的话，他们是可以用那个视频的方式去记录整个过程的。那当然，如果说他们能够再快速的用视频拍到警察的证件的话，这个也是 OK 的。但是他们通常不会直接同意你对他们的证件进行拍照。那对于视频记录的话呢，这个如果说是发生在你家里，或者说在一些比较公开的地方的话，这个视频是 OK 的。但是如果说这个视频妨碍到警察执行公务了，或者说是在一个平时就是一般人是没有办法进入的地方，比如说在警察局内，那这个视频可能就没有办法进行记录了。所以总结来说，关于视频来讲的话，如果说有执法机关来你家里面搜查也好，来你家做任何的这些动作也好，用视频记录的话是可以的，只要不妨碍执法机关执法的情况下是可以录视频的。那接下来呢 ，Keith 律师呢会再继续的讨论，就是关于同意的这件事情。Keith, please.
Okay. So how do you prove that you didn't consent? Well, first off, you have to understand the government has to prove that you did consent. Okay, the burden is on them to prove that you did consent. So they have to convince a judge. This is a legal issue that the judge alone decides, not a jury, just the judge. And they have to convince the judge that you consented. How do you respond to the government's evidence? You can testify. You can call witnesses to testify. You can show any physical evidence that may elaborate on what happened, such as video testimony. Anything that you can think of that's relevant to the issue is admissible to help the judge make that decision. But it's the government's burden to prove it. One thing to know that, when you testify that you did not consent to a search, you are protected from having any admissions you make about that crime come in at trial. They can't force you to choose between your Fourth Amendment right or your Fifth Amendment right. I'm sorry, Sixth Amendment right. So you basically have the type of immunity that I discussed earlier. If you're going to testify, I didn't consent to a search of my house, and then they ask you, well, how did those drugs get in there? And you say, well, they were mine, because you don't want to lie because you're under oath, right? You're not going to go to trial and hear a prosecutor stand up and say, well, at a motion to suppress, the defendant admitted that the drugs were his. That's not allowed. That's an instant mistrial, and you walk out the front door, and you can't be prosecuted again. So
OK.
That's the short answer to that.
对，刚刚Keith 律师也说了，之前的问题有问到说，如果说警察来你家，在没有搜查令的情况下想进行搜查，那怎么来确定说你确实是给了警察同意？如果说，比如说你说你没有同意警察进入，可是警察说你给了他们进入，那怎么去同意？那这个问题呢，Keith 律师也很好的解答了。首先，在录像是合法的情况下，如果说你有亲友把整个过程记录下来，这可以成为一个很好的证据。再来的话， 就是说，在整个过程中，警察那一方是他们有责任去提供相关的证据来证明说你的确给了同意，也就是说你不用提供证据说你没有同意警察进来，而是相反的，警察要提供证据说你同意了。所以说这个时候就是警察那边他有这个责任，我们这边叫 burden of proof， 就是他有这个 burden 去提供所有相关的证据。当然如果说你这边有视频记录的话，那你就可以很简单的用这个证据去驳倒警察那边提供的证据。再来的话 Keith 律师也是提到了，如果说警察当进入你家搜查的时候是没有搜查令，或者他们违反了相关的法规，那在搜查过程中取得的证物，或者说在根据这些证物而提供的一些供词的话，都是会直接被法院剔出在整个案件之外的。也就是说，在这种情况下，你就会直接被无罪释放，不会有任何的问题。好 ，Maggie， 那还有什么问题吗？
我们这边还有一个问题是说，如果执法机关开始调查以后没有继续立案起诉，但是大学把这个大学教授开除了，那么请问这位教授可以要求学校继续雇佣他吗？他可以告执法机关吗？谢谢。
Okay, Keith, we have a second question.
Okay.
So the question is, if the law enforcement or FBI arrested someone or suspect someone of any, criminal activity or espionage, and this person got arrested or maybe even got charged, but later on the charge was dropped or no charge has been filed, but as a result of this arrest or potential charge, this person suffered personal damage in terms of, careers. For example, if this person is a professor at a university and because of this, suspected criminal activity, this person got fired. But, later on, there's no charge has been filed or the charge has been dropped. What's the remedy this person has? Can this person sue the government, or can this person actually force the employer to hire him or not fire him because of this?
Sure. Well, that's two separate things. In terms of suing the government, you can file a civil suit against the government for arresting you without probable cause. Suing someone for prosecuting you is very difficult unless they violate some other right, like withholding evidence from you or fabricating evidence. But prosecutors and people engaged in the prosecution of crimes and their office staffs and what have you have immunity from suit. You can't sue them. You can only go after the officers, and then you have to show that the officer did something more than simply participate in a prosecution that didn't go anywhere. It happens that arrests are made and cases are dismissed. That's a good thing. A prosecutor should dismiss a case if it turns out that the information they were given wasn't sufficient in the first place to go forward. But that doesn't necessarily mean that anyone made anything up or committed anything nefarious that led to that prosecution. So it's possible, but it's difficult. And if that's the situation, there are a number of experienced lawyers who can help with that. So
okay.
As far as the suing your employer, I'm not an employment lawyer, so I don't really know the ins and outs of it. Here in California, if you don't have a written contract, you can be fired for any reason. That's something you should talk to an employment lawyer about.
OK， 对，Keith 律师是说像这种情况的话呢，你可以去告政府或者告这些执法机关，在他就是说逮捕你的时候没有任何的理由。但是呢，很多时候呢，像这样的诉讼或这样的起诉呢，它是很困难的，因为警察一般情况下他是不会没有任何理由的情况下去逮捕你的，除非说警察方面的话可能会有一些伪造证据啊，或者就是其他的这种违法的行为，不然的话呢，其实是很难 去直接去起诉美国政府或者警察的。那至于说可不可以让雇主，或者说是起诉雇主或让雇主不把你给辞退，那这个呢，基本上在加州这边的话，因为雇佣关系的话是一个双方自愿的一个关系，所以说其实雇主在任何情况下都可以用任何理由去解雇一个雇员。这个的话就是里面的细节的话，可能就是需要去跟专做职业方面的律师去沟通，有没有其他的方法可以去向雇主寻求赔偿。但是光说从起诉警察方面的话呢，是相对来说是比较困难的，除非有其他相关的证据，警察在整个的执法的过程中有其他的违法行为。OK， 好的 ，Maggie， 还有其他的问题吗？
好的，我们现在下一个问题是，首先感谢 Kiss 律师以及庞飞律师受美华总组织这次讲座。然后他的问题是，请问 Kiss 律师如何看待第2次世界大战期间在美国珍珠港受到轰炸时，在美的日裔、德裔、意大利裔民众受到美国政府集中隔离对待？他认为，在美中关系低潮时期，这种大面积冲击平民亚裔和华人的情况会在美国再一次发生吗？作为一位美国公民和市民，该如何保护好自己，以及他对华人这个群体有什么建议吗？谢谢。
Okay, Keith, the third question is, during the Second World War time, people with Japanese descent were put into concentration camp, or generally the society or the law is very hostile toward certain people from certain descent. Yeah. And do you think that will be a problem recently, against people with Chinese descent? Is there any way, we can better protect ourselves? What's your recommendations?
Well, that's a little bit outside my field of expertise. That's really something for the ACLU, is fighting very hard for that. Mm-hmm. I think you should wait 54 days to the election, or however it is, and then those types of possibilities will settle out. But know that if anything like that did happen, there are tens of thousands of lawyers in the United States who are ready to spring into action to prevent that from happening.
OK， 对，基本上这个问题呢是比较就是超出了这种刑法的一个范畴吧。像这种情况的话呢，其实在美国有很多就是相关的一些人权律师啊或者其他的律师啊，他会想尽办法去保护就是每个族裔的人。那就像之前提到的，在那个2战时期，那美国这边可能对一些日裔的人士呢，他会有一些不公平的对待。那这些东西呢，基本上也是在战后呢，也都是得到了平反。所以说这一块的话呢，我们还是需要就是说进一步观望。但是就是说我们还是看之后的大选啊，包括一些政府的一些它的policy 的走向。
下一个问题是 at airport when the cop without a warrant stop you to get on board and request to seize your laptop or cell phone, do you have the right to decline, or do you have give them your electronics? And at airport, if the cop questions you, can you keep silent and ask for attorney? Thank you.
Allow me to translate into Chinese real quick. 这个问题的话，就是说如果说在一个机场，那有警察在没有任何的收查令的情况下，想要就是阻止你登机，然后要求去就是去seize 你的这个电脑，包括你的手机，在这种情况下你可以拒绝吗？然后还是说你必须要把这些东西提供给警察？然后在这种情况下，你有权保持沉默吗？你有或者说持有其他去要求律师的一个权利吗？ OK， Keith?
Okay, yes. The second part is easy. If a police officer questions you at the airport, you absolutely have a right to remain silent and ask for a lawyer. If they want to stop you from getting on board, if they want to stop you, they will stop you. You can't fight back, basically. If they want to take your stuff, your computer or your cell phone, if they want it, they're going to take it from you. They can't search it without a warrant. They can take it from you probably under the exigent circumstances exception to the warrant requirement, only to hold it pending a warrant in order to prevent you from deleting whatever that they think is on it. But that's rare that happens. Usually when they're arresting someone at airports, it's because they are already armed with a warrant and they follow that person to the airport. Otherwise, it would have to be like just a random.
OK， 对，这个问题的话是有2个部分第一个部分呢，就是说对于警察去拿你的电脑或者说手机。第2个部分呢，就是你有没有权保持沉默，然后去寻求律师的帮助。那对于第2个问题呢，是有的，在任何情况下，如果说警察想要逮捕你的话，你都有权保持沉默，你都有权要求律师在场。所以说这个部分的话是比较容易的。那在第一个部分，就是警察有没有权去，或者说手机呢？这个呢，一般情况下警察是会有这个样子的权利去没收你的手机的，包括他也有权利不让你登机。这个时候呢，你是不能跟警察去强行的不听从警察的指令的。那一般来说，他拿了你的电脑，如果说他是没有一个搜查令的情况下，他去没收了你的电脑跟手机以后呢，他是没有办法，是不能合法的去动你电脑里面，或者说看你电脑里面的信息跟你手机的信息，他只能把你的这些东西暂时没收，然后呢，他再去向法院申请搜查令来搜查你里面的这些文件跟内容。但是呢，Keith 律师也说了，以他的经验来看呢，通常如果说警察在机场去逮捕你的这种情况呢，通常情况下他们已经对你做了很完善的调查，他们也已经从法院通常都会已经拿到搜查令跟逮捕令。所以说在这种情况下呢，通常情况下呢，他们都是有权没收以后直接去看手机里面和电脑里面的东西的。如果说他们没有这方面的搜查令呢，他们只能没收，只能把它暂时收起来，然后再跟法院去申请搜查令，拿到搜查令以后呢，才能打开你的电脑看里面的文件。
Okay. Next question. If the FBI does come with a warrant, what should you do? Can you still keep silent? Absolutely. When they come with a warrant, your responsibility is to get out of their way. If they direct you to sit in a certain place, just go there and sit, remain silent, and just wait for them to finish. Just because they're searching doesn't mean they're going to arrest you. Sometimes they do, sometimes they don't. If they ask you for your password for a laptop, whether it's at an airport or anywhere else, you're not obligated to give that information.
OK， 对，刚刚Keith 律师是说，如果说 FBI 在有搜查令或者逮捕令的情况下，我们该怎么做？那还能不能就是保持沉默？保持沉默这个是肯定是可以的，在任何的情况下你都有权，就是在任何这种逮捕的这种情况下，你都有权保持沉默。然后那如果说他们有搜查令的话，我们该怎么做？基本上如果说这些执法机关有搜查令的话呢，我们就要就是说听从执法机关的所说的，就是他要搜查的地方就是让他去搜查，就是根据搜查令，因为之前的也提到过了，搜查令的话呢，它里面都会记录的比较详细，什么地点搜查哪些地方，所以说只要是搜查令里面包含的这些地方的话，我们就是有义务要去给警方或者说这些执法机关提供这样的 access， 让他们去搜查。然后如果说机场里面你的电脑被警方没收了，他们问你要电脑的密码，你有没有 义务要去提供呢？这个呢，你是没有这方面的义务的。
Well, the news is just coming in. The hearing on the TRO of the WeChat ban. The judge in the federal judge in San Francisco, going to grant the order to tentatively hold the WeChat ban for Chinese Americans. So that's going to be a big news because they have an emergency hearing as well when our seminar going on. And for today, I think we thank Keith to spend 2 hours, more than 2 hours to share with us very valuable information. I think in America, we should know our rights, especially our rights which was protected by the US Constitution. And I think that is very important for the first generation Chinese American to study and learn the Constitution and try to help the community. Okay, I think that's it for today's seminar, and the seminar will be recorded and it will be shared and then editing, and then we'll publish it at the Chinese American Federation's official website and also on our own law firm's website. 那么今天呢是很感谢 Keith 律师在这个本身是犹太节的新年节日专门还抽了2个小时来跟大家分享这个宪法的一些就是说权利。那么这些权利呢其实很重要。那么我为什么刚才提到说微信的这个禁令，其实刚才是在我们在做这个讲座的同时呢三藩市的那个关于微信的禁令的这个诉讼也是举行了一个紧急的听证会。目前看起来的话，这个法官会发出一个临时的禁制令，就是禁止川普政府去实施这个微信的禁制令。所以这个也是我们在美的华人如果团结起来争取，根据美国的法律来争取我们该有的一些权利的另外一个胜利。那么我们实际上是说希望这个讲座通过跟大家分享，让大家知道自己的一些权利，在这个基础上呢至少是能够保护好我们自己的社区，还有我们自己本人或者家庭的一些合法权益。会后呢我们这个video 然后会放到这个美华总的官网，那么也会放在我们律师事务所的官网，所以欢迎大家到时候去官网去看。Keith, thank you very much for
You're very welcome.
This webinar, and if we have after this webinar, if we got any follow-up questions, I will email it to you.
Okay.
And then we'll see how we can answer any follow-up questions
Sure.
from the members. Okay.
Sure. Yeah.
Thank you and happy holiday for you.
Well, thank you all very much. It was my pleasure.
Thank you, Kay. Thanks a lot for the seminar. That's great, helpful. Thanks a lot.
Good. Okay. Thank you, everybody.
Out.
Bye.
All right. Thank you.
Thank you.
Thank you.
Bye-bye. Thank you. Bye-bye.